Well, hello everyone, and welcome to part 4 of TFO Family Office Partners' 9-part webinar series, Optimizing the Sale of Your Business, which is designed to help business owners plan strategically for a sale within the next 1 to 3 years. I'm your host, Damon Miller. I'm a family wealth strategist and one of the partners of TFO Family Office Partners. And here at TFO, we are a full-service multifamily office. We are fortunate to serve over 300 families across the country with over 65 colleagues that have deep expertise integrating various aspects of our clients' complex lives. And a large portion of our client base is current or former business owners, which is what led to the genesis of this webinar series. Our mission is to empower families to thrive by helping them connect their wealth with their purpose. So the past 3 webinars focused on tax strategies, estate planning, and optimizing your business structure prior to a sale. In today's webinar, we will discuss the legal side of the equation, including pitfalls to avoid during the sale process. Before proceeding with today's presentation, we have a few housekeeping items to address. Today's event is a webinar. By default, all attendees are muted and have their videos turned off. Today's event is being recorded, and a recording of the webinar will be available later. At the bottom of your screen, you will note an icon for a Q&A. And if you have any questions throughout today's event, please use the Q&A to submit them. We'll try to answer them on the fly, but if we don't get to them, there'll be time at the end where we'll go through all the questions aloud. As I mentioned, today we're focusing on legal aspects and pitfalls to avoid in the sale process, and I'm joined by Jonathan Ariano. Jonathan is a partner at the leading Phoenix-based law firm, Osborn Maledon, whose practice focuses on representing growth-oriented and entrepreneurial clients, often in connection with the firm's outside general counsel practice. A significant portion of Jonathan's practice relates to mergers and acquisitions, typically representing the sellers. And Jonathan is going to answer questions related to the process of selling your company, which advisors to engage in when, and tips to avoid common mistakes. So thank you for your time today, Jonathan.
Pleasure to be here.
All right, well, you want to jump right in?
Sounds great.
So
actually, before we get started, I've got
sure.
one thing I've got to say. As Damon mentioned, this is for educational purposes only. I am not giving legal advice to any individual person, because if so, we'd have to enter into an engagement letter, and then you'd have to cut me a check and pay me. So we don't want to do that in this particular webinar.
Yes, no attorney-client privilege on this one. I get it.
Exactly.
All right, so if I'm considering selling my company, what's the first thing you think I should do?
Well, first thing is make sure you're ready to sell your company mentally. Most people that own companies that have done it have been doing it for quite some time, and it's their child. And are you willing to give that up at this point? Because it's probably the biggest life adjustment you would have, and it's tough for some people to accept, and they might think they're ready, and they start to go through the process and then realize, ooh, maybe they're not, and probably finding that out sooner rather than later is better. But assuming then you have decided that no, this is the right time, and you want to get that process started, I think the next most important thing to do is surround yourself with the right advisors. And that partially is a self-serving comment, meaning get yourself a good lawyer, an M&A lawyer who can help you through the process. But in addition to that, you also need a lot of other advisors to help as well. There's accountants who are familiar with the M&A process is also important, and that may not be who does your current accounting and tax prep and things like that today. That's something to keep in mind. Having people that have been through M&A transactions, in my opinion, is absolutely critical. I did a transaction for a client probably about 3 years ago now. It was actually right before, maybe 4 years now, right before COVID. And they had an accountant they had worked with for obviously did all of their both bookkeeping and tax prep and all of that kind of stuff. And it turned out that didn't have experience in the M&A world. And when we were talking about things like purchase price adjustments and things like that, that we, we'll probably touch on later, it became a challenge, actually. And we actually had to go and try to sort of put it on pause a little bit, bring in someone who had that experience, get them up to speed so that we could get the support we needed. And you don't really want to have to try to, the process is stressful enough. You don't want to have to try to do that in the middle of a transaction. And then I think in addition to that, business brokers or investment bankers, I think they're both kind of different names for the same type, are people that are, just like when you buy and sell a house, right? You've got a broker, and they take you around, they try to find you right places. If you're the seller, right, they might bring buyers to you. That's exactly what these brokers do in an M&A transaction, and they can be expensive. They cost money, and usually it's based on a percentage of the transaction. But in my experience, with the right broker and or investment banker, you can actually get they more than cover their fee and their added value.
Yeah, we often talk about, if you're going to sell your business, it's got to be the right price and the right time, and then surrounding yourself with that good team. So in your opinion, how do you find that good M&A attorney? How do you know if you have someone who has that experience?
Yeah. Honestly, most lawyers have obviously websites, and you want to go and search for that. Well, let me put it this way. In my opinion, the best thing to do is word of mouth. Talk to people that have been through the process of selling and ask them who they've used and if they've been pleased. I would tell you that 90% of my client referrals come from other clients I have done work for. And then once you have that, and hopefully you can get a couple of different names of different attorneys to work with, look at their website, look and see what they have done. One of the things that I think is important is getting a representative sample of types of transactions they've worked on. What's one of the things we do at Osborn Maledon, we have a section of our website called Notable Transactions, where we have what are called like tombstones, which identify like the transactions that we've been involved in, and take a look at that and look at those businesses and look at those types of transactions that have happened, and do they align with your types of business? And if so, then that's probably a good sense that they might be attorneys that have experience in selling a business like your own.
So should we be looking for industry specific alignment? Is it size of business? What are kind of the big wrappers you think that make a good alignment?
Great question. It depends on, so first of all, every transaction sort of takes the same structure, really, no matter the business and industry. Overall, like they're all pretty much structured the same way. Having said that, obviously, finding an attorney who has expertise in your industry can be hugely beneficial for a couple of reasons. One, you don't have to necessarily bring them up to speed on your business and what you do. If they already understand your industry, that can be a big benefit. And there could be specific nuances, certainly, to your business. For example, if you might be in a regulated space or something like that, having counsel that has been through that regulatory regime and having to deal with that can be, hugely beneficial. Having said that, I like, for example, I may not have experience in healthcare, but we have been involved in M&A transactions that involve healthcare, and in doing that, either one, we can, most likely you will have counsel that already has some regulatory experience if you're in that space, but they may not have M&A deal experience. So we've many times come in to handle the M&A transaction, and then we'll partner with your regulatory counsel to get that specific guidance we need that, again, me as the M&A counsel may not necessarily have, but then again, partnering with your regulatory counsel, we can do that. And that's kind of across the board. Another element you might have is, if you've got a particularly complicated tax structure that we need to work with, we obviously, our firm has a tax attorney that we work with all the time. You'll want to make sure you've got that element covered, either with your own tax counsel that you might have worked with in the business, or, you know, the firm you choose, obviously having that as well.
So if I'm looking to sell in a year or two, when's the best time to engage someone like you? Is it way ahead of time? Is it just before the LOI? Is it after the LOI? When is ideal?
Yeah, so certainly, in my opinion, it's best to do it at the latest right before the LOI. And a big part of that is because, in my opinion, in my experience, and again, I've been doing this for 20 years and handled, you know, many transactions. I believe that as the seller, one of your most leverage is likely right before you sign the LOI. And the reason is, there's a couple of reasons. Even though, you know, you have to appreciate, right, most LOIs are non-binding LOIs, right? Which means that, you know, you might lay out the business terms, purchase price, some deal structure, you know, whether or not how consideration will be paid, whether there'll be escrow. These are all things we can certainly talk about. But those deal terms are typically in the LOI and do not create a binding obligation for either party to move forward on those terms. Having said that, most deals will close on the terms you negotiate in the LOI, absent, of course, something that comes up during diligence, right, which might dictate a change to those terms, both positive and negative from the seller's perspective. You know, if, for example, during diligence, the buyer finds some problem that came up, for example, maybe you haven't been paying sales tax in every jurisdiction that they think you should have been paying sales tax in. That could be a risk, and they may say, you know what, we need to change the deal terms because there's new risk involved we didn't know about at the time we negotiated the LOI. But again, I believe that having your attorney, your M&A attorney involved at that M&A right before the LOI is extremely helpful, because we can guide you through what's important to include in that LOI and what's not. And again, being non-binding, I think a lot of my clients take the assumption that they want to get over that hurdle, right? They want to get over the LOI, they want to get that signed and move on to the next step so they can get to closing. The problem with that is, in my opinion, that so again, sorry, let me go back. I mentioned the LOI is non-binding. There are elements of an LOI that are binding, and that's what makes this so important. So one of the elements of an LOI is confidentiality, obviously, right? Each party will want to make sure that all the information that's exchanged is confidential. That can be done in a separate NDA before you even get to the LOI stage, which is typical, or if not, it's certainly covered in the LOI. Another part is there will be, you know, 99% of the time, exclusivity, which basically means that once you sign this LOI for a period of time, and that's usually going to be 30 on the low end to 90 to 120 days on the high end, during that period of time, you as the seller will be precluded from being able to go out and discuss a potential sale of the company, your equity, or anything like that. And the primary reason is the buyer is going to, once they enter into the LOI, likely going to be incurring a bunch of expense on their end, right? They're going to be hiring lawyers to draft agreements. They're going to be going through diligence, hiring accountants to go through and review the books and records, all of that. And they would not want to and go and incur all that cost if somebody can come in and take the deal out from under. So, and so that's why the terms of the LOI are so important, because before you sign the LOI, the buyer doesn't know you're on the hook, right? They don't know that you're necessarily going to do the deal with them. So they are going to probably be much more willing to compromise and negotiate the terms, but once you sign that LOI, they know they've locked you up now for 60, 90 days. So you can't go talk to anybody else, and they will likely be less willing to compromise because they know they've got you locked up. Now, that doesn't mean that as time goes on, you won't be able to renegotiate things as things happen. It happens all the time, and you will. But like I said, I think, in my opinion, the most leverage you have is sort of right before you sign that LOI. And because of that, one of my typical recommendations to my clients is put as much detail in that LOI as you can, right? If there are elements to the transaction that are important to you, like if there's going to have to be money put into escrow or there's a holdback from the buyer, or there's seller financed elements of it, or there's an earnout, put as much detail in that LOI because if it's important to you, get that in there now while they're still in compromise mode. Because in my opinion, buyers most of the time want a very simple LOI. They want the minimum amount necessary to get you on the hook and lock you up. So they won't put details in there. Then once it's signed, all of a sudden we start negotiating the details, and again, they're going to probably be less willing to compromise. If you put those details up front, I a lot of times, you'll hear buyers say, well, we'll just deal with that later. And there's a reason why they're saying that, because they know they'll have more leverage later. So my advice is put as much in up front and get that LOI in as solid of a form as you can.
Yeah, and just to clarify, LOI means letter of intent. I probably should have started with that. But it's also non-binding. So if you get cold feet, you could walk away. You just can't get other offers to.
Absolutely. And to be honest with you, I mean, it's non-binding all the way till the day you sign. I had a transaction probably about 4 years ago, where they were I wouldn't call them unwilling sellers. They were sellers, right? I mean, it was their choice to go through the process. They found a buyer. The numbers, they liked the numbers, and we signed the LOI, went through the whole process, negotiated the entire terms of the purchase agreement, did all the work through diligence, did everything. And it was literally the night before closing when it was scheduled to occur. And my client literally got cold feet and said, you know what, this just doesn't feel right. We don't want to do it. And they pulled the plug. I will tell you, the buyer was not particularly pleased and they were unhappy. But at the end of the day, they didn't have any claims, because it was all very crystal clear that was non-binding. So, you are not bound to do the deal until you sign the definitive purchase agreement. And it's for that reason that I always recommend you shy away from binding LOIs. And I have had clients who have gone ahead and done that and then come to me after the fact. And to be honest with you, that's a really risky scenario, in my opinion, because all of the details not there, right? We don't know what the definitive terms of that transaction are. So if you get to a point now where you're negotiating those details and you can't agree, what happens? Now at that point, unfortunately, you've got potential claims against the other party because you've got a binding deal, but we don't know what the terms are. And that creates, again, ambiguity breeds dispute. And that means then you're not talking to me anymore. You're talking to like my litigation partners, and that's usually not advancing the ball. So my advice is stay away from a binding letter of intent under almost every circumstance.
So obviously, letter of intent is a key document in this process. Can you talk about the typical process and what other documents are needed in selling a company?
Absolutely. So I would say that I'll talk process first. That's likely dependent upon whether or not you've got a broker or banker involved, and whether or not you are going out to a broad group of potential buyers, or you've just got one specific buyer that's come to you and you're marching forward. If you've got that one specific buyer, sometimes it can be a strategic, can be a supplier, could be a customer, could be a competitor who comes in and says it's just a good fit and they want to buy. And you may just be negotiating with that one party. And if so, then that process would look like, you would have initial discussions, you disclose certain things to them. Certainly when it's a competitor that you're negotiating with, you've got to be super cautious on what you share with them and when. Obviously you'd want that NDA to be super tight, non-disclosure agreement, obviously, to be super tight, because you would not want a scenario where you disclose to them a bunch of information that's competitively advantageous to them. They decide we're not going to do the deal and walk away and use that information to your detriment. And you know, NDAs and confidentiality agreements are great. They're strong, but remember, all they do is give you a claim if someone were to breach it. You've still got to likely go and sue them to get them to stop, or to get a damage claim against them, and that's incurring a whole bunch of cost that you'd rather not have. So the way I usually recommend protecting against that is you have to really filter what information you give them and when. You know, you start out super high level, not giving a lot of detail and anything like that. I actually did a transaction. This is probably about 10 years ago. We did a transaction where it was it was probably an $80 million deal. Their next biggest competitor was buying them. And, you know, one of the things we had to put into the purchase agreement was the list of the top 20 customers and their revenues and all of that. And we literally, it was the night before closing, we still had company number one, company number two, company number three. We did not identify who they were, and it was literally at the closing on the wire transfers. We then updated them with the proper documents that had the competitive. That way, then if it blew up before the money transferred, you know, we tried to minimize the damage as much as you can. So, you know, throttling exactly what information they get, in my opinion, is critical. Then you get to negotiate the LOI, and then after the LOI, there's a bunch of other documents I'll talk about in a minute. So that's all if you've kind of got one strategic buyer that you're sort of working with. If you're running more of a process where you know, you've hired likely an investment banker or a broker to come in, you know, they will come in and, first of all, they'll spend a bunch of time learning about your business, right? They have to understand your business, they have to understand your industry. Then they'll likely put together a one-page kind of you know, summary of the business. It might be even on a no-name basis. It might just talk about the company up from a high level. Because you know, one thing you don't want to have happen is you don't want it out there, especially like to your customers, that you're up for sale, because that can spook some customers, and you don't want those customers, you know, going elsewhere to your competitors because they're worried you might not be around anymore, or that the service could get worse. Who knows? Whatever the case might be. So a lot of times they'll do a one-page teaser that doesn't have any, you know, no names. It'll just talk about the business, some high-level economics, things like that. And then if they sign the NDA, then the banker or broker will give what's called like a confidential information memorandum, which could be a, you know, 3 to 50-page detailed document giving much more detail about the business, and that. That'll be sent out to a bunch of people. At that point, then there may be they might request indications of interest, which is sort of a light letter of intent, right? It's sort of, we have interest here. We're thinking of a price in this range, and this is the kind of deal structure we'd be considering. Something super, super high level. And then those are usually taken and compared, and then you take a look at those, and you might narrow that down to 2 or 3 people, and then you might solicit true letters of intent from those, which would then take you into the process of exclusivity when you finally pick one, because, you know, you're going to have to pick one. You can't likely have multiple letters of intent because of that exclusivity issue we talked about earlier. Once that's done, then and by the way, usually up until that point, your lawyers are not on the front lines, right? They are not actively involved in the negotiation or anything like that. Now, we are supporting you on the back end because, you know, we want to be there to make sure the letters of intent have all the terms we want and all that. But you're not usually having lawyers talk to lawyers at that point, primarily because the buyers aren't likely to engage their counsel yet. They most likely, if they're private equity that's buying, or, you know, a private equity firm that's buying, or if it's a strategic, you know, they likely have business development people that can do the LOIs themselves, because they've been through this, you know, hundreds of times. So, and again, because of the ethical rules that lawyers have, I'm not allowed to talk to a business person on the other side without their counsel present. And they're not going to want to have their counsels present at this stage until they know they've got that exclusivity locked up. So I have to support my clients on the back end. And you as the business owner has to be negotiating that on the front end. And that can be tough because you're also trying to run the company at the same time, right? So that's where, I do think having a broker or banker can help because they can be that front line handling those negotiations. And then, you are also on the back end helping them with that. But once you get to that LOI, then, we're off negotiating the purchase agreement. Typically, 7 out of 10 times, I would say the buyers draft the purchase agreement. And then we get a draft of that. We have to go through, we have to then build disclosure schedules. We have to look at if there's going to be a transition services or some form of employment agreement for you and your team potentially who move on. Likely a non-compete agreement. You'll likely have to do board and shareholder consents. And to get all the necessary approvals. There might be an escrow agreement if certain portion of the purchase price is being put into escrow. You might have to if you decided to go out and get what's called rep and warranty insurance, which is actually insurance to protect against claims from the transaction itself. That's a whole nother set of documents and negotiations that need to happen. Although most of the time that's done on the buyer side than the seller side, but there have been seller side policies as well. And then there's, hundreds and hundreds of other pages of documents that are part of the transaction. You would think that lawyers get paid by the word when you see how many documents there are. But, the good news is there is sort of a standard typical process and set of documents that both buyers and sellers are used to seeing. And so there's not that much negotiation on form. It's more the substance of the terms.
So from your experience, having been through a few transactions, how good is the buyer's legal team typically?
Yeah, extremely dependent on who the buyer is. Certainly if it's a private equity firm that's been doing this before, that's done this a bunch of times where they come in and buy companies, they're going to have very good counsel. They're going to have counsel from probably one of the bigger law firms. Those teams will be anywhere from 2 to 20 lawyers, to be honest with you. And that may sound like crazy, but it's absolutely true. I've been on diligence calls where there have been, 12, 13 lawyers from the buyer side on there. And it's because each of them have a particular expertise, right? They might have IP lawyers who are there for a portion of the call. They might have, tax attorneys who are there to talk about tax structure. They might have regulatory lawyers. So all of that stuff has to plug in. Most of the time on the seller side, again, we usually do transactions in the, $2 to $150 million range. Our deal team size is usually 2 to 3 to 4 people, to be honest with you. And many times they'll say, well, can we please talk to your IP expert? And I'd be like, that'd be me. Can I talk to your deal attorney? That'd be me. And structure that. Having said that, like I said, we will sometimes bring in, if there's deep expertise that we need and we don't have, we'll bring in outside people. But those teams and those lawyers are usually they're usually very good. You're not going to get anything by them. You're not going to trick them. I truly believe in transparency when going through this process, because they're going to find out if there's problems. We need to disclose those to them during this process. Now, how we disclose them is important, but disclosing it is critical in my opinion. The worst. So those are like private equity and bigger firms that do this. Next are like strategics, large publicly traded corporations. They might actually run it all entirely in-house. They may have in-house counsel that do M&A deals, and if so, they'll run their own process with internal staff. Most of the time, though, it's usually a hybrid. Like they'll have in-house counsel that will run the transaction, but they'll use outside counsel to help kind of move the paper, draft the documents, and that kind of thing. And it's usually a hybrid like that. The worst transactions, in my opinion, are when you've got a buyer who does not have counsel that is used to doing deals. Because as I mentioned before, there's a certain structure that all deals take, and certain set of documents and forms and that most companies use. or most buyers use. And if you end up having a lawyer who's not used to doing this, and they draft the purchase agreement like they would a, reseller agreement or commercial agreement that doesn't follow this similar structure, it can be painful because you have to educate them on the process. And painful means it takes a lot of time, and a lot of time means you have to pay your counsel a lot of money, and it's just inefficient. I far prefer to be against really good lawyers on the other side, because we all know what has to happen. We all know where we're going to end up at the end of the day. We just have to then negotiate to get there, and it ends up being far more efficient.
Well, speaking of pain, is the due diligence process really as painful as people say?
Ooh, yeah, unfortunately, it is. What the diligence process is going to be like the following, right? You're gonna sign that LOI, and then probably a day or two later, you're going to get a 20-page document of questions and document requests about the business. Financial, employment, intellectual property, regulatory, legal issues, formation, your cap table, everything related about it. And it's going to take weeks of full time to pull all of that information together. Some of it is just supplying documents that already exist. Some of it is you have to create summaries sometimes to explain these things. And so that's step one. Then that will go off to the buyer. Their teams and their lawyers are going to read through all of that, and they're going to put together a whole bunch of questions, follow-on questions or follow-on document requests. And that's going to happen for 2 or 3 rounds of this. And then there'll be diligence calls where you'll get on these calls, and for 4 hours you're sitting there in the hot seat answering questions about the business or taking notes and explaining things. And you're going to feel like you've done that over and over, and you've already explained it, and you're probably having to explain it to different sets of people, different times. And you're going to call me up if I'm your counsel and complain and tell me that, what is this? This is ridiculous. They're just trying to run up the bill. And the answer is not really. They're just doing their job. And the purpose of it, remember, is they are going to be buying your business, and they're going to step into your shoes. And they've agreed to hopefully pay a significant sum for your business. And they need to know what they're buying. And the only way they can do that is to, 1, ask questions and get documents from you to find out. And then 2, whatever you put in the purchase agreement and the reps and warranties and disclosure schedules that we disclose against are the second piece. But I will tell you, I mean, I've had clients like literally at wit's end say, this isn't worth it. I can't do this. My business is suffering because I'm trying to do all of this. And that's why making sure you've got the right people surrounding you to help. You cannot do it by yourself. And I know that's a struggle always with sellers, because in their mind, they may not want to tell anyone else in the company that this process is going on, obviously, right? Because, just like we talked about spooking customers and that, even worse, spooking employees who think, oh gosh, the business is being sold while I have a job tomorrow. That just creates horrible uncertainty. So I think you kind of have to approach that one of 2 ways, to be honest with you. I think you either need to be completely open and transparent with everybody. That can be a risky venture, though, to be honest with you. You got to think about that, because you can't stop people talking. You can't stop the rumor mill. And sometimes people, things can wind up and people can get themselves in a frenzy. Usually what you do is you'll start out and it might just be you, and then you'll bring 2 or 3 more people under the tent to help you with the process. And they're then sworn to secrecy, obviously, during the process. And then you might then bring more people into the tent, and that's kind of the way you start the process. And then it also has the benefit of that if it doesn't go through, you've minimized who the disclosures went to at that point, and can hopefully minimize if there is any damage through that process.
Can you go a little more into what is a disclosure schedule and why is it important?
Absolutely. So in the main document in selling your company is a purchase agreement, and it could be an asset purchase agreement, a stock purchase agreement, an equity purchase agreement, depending upon if you're an LLC or a corporation, and so it doesn't matter. But at the end of the day, they're buying something in exchange for cash, equity, something else. And in that document, you will probably have 20 to 30 pages of representations and warranties you're going to have to make about the business. And that can be anything from, the company has not had any litigation in the last 5 years, to, the company has complied with all employment laws, or there have not been any terminations, or there have not been, no one has left the company in the last 5 years. No seller could ever make any of these representations and warranties as they're written. It just that would just mean you're not operating a business, because every business has issues that would need. So, but the purpose of the reps and warranties is that you build what's called a disclosure schedule that maps onto those reps and warranties. So like section 3.1 may say the company has not been involved in any litigation in the last 5 years. Well, let's say you had some dispute with a customer that you ended up having litigation filed and you ended up settling in the last 3 years. You would not be able to make that rep. So what you do is you create what's called a disclosure schedule that would say section 2.1 of that disclosure schedule says, in January 3rd of 2021, such and such customer brought a claim against the company for X, Y, and Z, and you describe what happened and how that was settled. And so that would then, so when you read the rep and the disclosure, because every representation is, except as set forth in the disclosure schedule, the following is true. So when you read those two together, now it becomes a true statement. And there's a whole bunch of benefits of that. The first thing is it makes you do your homework to think about everything you can think about in the business and put it on a piece of paper so that the buyer knows what they're buying. So that's step one. Two, it obviously teaches the buyer to know about, okay, what are the issues that have come up in this business and what am I getting myself into? And then the third thing is, if you disclose it in the disclosure schedules and the buyer closes and signs the agreement and closes on the transaction, they cannot bring a claim against you for anything you put in that disclosure schedule. So I like to think of it as your insurance policy, right? If you put it in there and they close, it's called closing over the disclosure, then they bought the business knowing that. If you didn't put it in the disclosure schedule and they later find out about it and it caused them a damage, then they can bring a claim against you for breach of the agreement and bring an indemnity claim against you. And that means they can come back and claw back some of the purchase price they may have already paid to you. And that's really the last thing anybody wants. So my advice always is over disclose, right? Because it's your insurance policy. Now, you have to be careful, because how you disclose is critical. Because if you disclose, if you were to go out there and say, we've had all of these issues and that, you could scare the buyer off, and they could say, whoa, this is a rat's nest. We don't want anything to do with it. And they could go and not close the deal. So how you disclose is critical. And that's where like I said, having an attorney who has done deals before will know how to word things in a way that gets you the protection of the disclosure schedule, but isn't likely to run the buyer off.
So with a typical transaction, you've got the purchase price and then an earnout. In your experience, how often is that earnout hit? So if a buyer's proposing a structure to get to the price with a big earnout, is that a good thing or not so great thing?
It's a great question, and I'll tell you that. So deal. Let me go take a step back to kind of make sure everybody appreciates what an earnout actually is. So deal consideration can take a couple of different structures. One is cash at closing. Obviously, that's likely preferred because that's money in your pocket day one. Cash at closing. The second thing could be a portion of it be seller financed, right? Where the seller agrees that they'll be paid out in installments via usually like a promissory note over a period of time. That's not contingent on how the business does post-closing, but is just fixed amount that's got to be paid no matter what happens. That's certainly not as good as cash at closing, but certainly better than an earnout. And what an earnout is it's usually consideration that's paid based on performance of the business after closing. I will tell you that in 2020 and 2021 and early 22, we did so many M&A transactions. We did more in that time frame than I probably did in the 10 years before, to be honest with you. And the primary reason of that was valuations were super high. All the stimulus money was put into the economy. That caused so much, everybody wanted to do a deal. And because of that, valuations were high. So we did a bunch of transactions. None of those transactions had earnouts. However, since the latter half of 22 and where we are this year, I'm seeing those creep back into transactions. And the primary reason is because I think that valuation isn't aligned with what a buyer thinks the company's worth and what a seller thinks the company's worth. And the way you can bridge that is through, like you said, an earnout, right? Where it's like, okay, we'll agree that the minimum that the value is worth is what's being paid at closing. But if it turns out, seller, you're right, and the value is up here, that's fine. We'll pay you that portion depending upon if it turns out you were right. The problem with that is you won't control the company anymore. So the buyer will. And you may not agree with how the buyer runs things post-closing. And guess what? It's their company now. So it's, I've always been asked by my clients, can you draft something to keep them from doing things that, that will hurt the earnout? And we try, and we can put in things there that will put in language that will keep them from, and it all depends too on how the earnout is calculated, right? For example, if the earnout's calculated based on profit, let's say, that can be, as you all know, right? You can gain profit depending upon what you spend and putting back into the business and all that kind of stuff. So I like to stay away from those kinds of things because that's hard to control. Basing earnout on top line revenue can be much easier because that's more of a hard number. But even that still can be, and especially if you're being bought by a business that and maybe being integrated into a bigger operating company, they can move people out of the organization that they just bought and move them into a different part. They can take expenses and tack them on. So getting those earnouts drafted and calculated that. The advice I give clients when we're negotiating an earnout is assume the earnout will be zero. Would you still do the transaction? And if your answer is yes, I won't. I would want more, but yes, I would still do it. Then okay, then let's move forward with the earnout structure. If the answer is no, I need to get some minimum amount of earnout, then we need to renegotiate these terms to get that minimum to ensure you're covered. Because I have done many deals, back to your original question, I have done many deals that the earnouts that are zero. I have done some earnouts where they're fully realized. And then I've done some earnouts where we have a fight because the buyer says we didn't meet it and the seller says we did, and we have to negotiate something. My job is as M&A counsel is to try to minimize the opportunities for those disputes to arise.
So slightly different gear. What does a net working capital adjustment mean, and how does it affect a purchase price?
Absolutely. So usually and these typically come into play when it's an equity sale or a merger, less than an asset sale. But when deal terms are negotiated, it's usually calculated on a cash-free, debt-free basis. So let's say, for example, I've got a business I'm going to sell for $50 million, and they say, listen, we will come in and buy it. We will pay you $50 million on a cash-free, debt-free basis, which means that if I have $1 million in the bank account as the seller, and they're going to come in and buy that, and we're going to leave $500,000 in the bank account so they have some capital to work with. That would mean that they're actually going to pay $50 million and $500,000 because the $50 million was assuming there's no cash in the business. We obviously don't want to actually close with no cash in the business because checks may have to clear and they need to make payroll in 2 or 3 days potentially. Who knows? So we'll leave cash in there. but that's an adjustment we would make to the purchase price. Usually with cash, we can do that at closing because we know what's in the bank account. Where we get into an issue is, and debt's a similar way. Like if you've got bank debt or something like that, most likely that bank debt is paid off at closing. And sometimes it's done with funds from the buyer. So at closing, instead of maybe 50 million going directly to the sellers, you might funnel 10 million to the bank to pay off the bank, so that obviously if they have a lien on assets, we're selling our assets free and clear and all of that. But because of that, one of the things that also happens is a lot of times buyers won't buy. Accounts receivable, for example, is an asset of the business, and accounts payable is a liability of the business. And so what a lot of times, if you think about it, right, if I'm the seller and I accelerate my AR before closing, so let's say I go to all my customers and I say, hey, I'm going to close this transaction. I'll give you a 10% off your bill if you pay it early, right? And you accelerate all that AR, what happens? That turns into cash. What did we say about cash? Cash we get to keep. So that would mean that, but they don't have as much AR as they were expecting. The buyer doesn't have as much AR as they were expecting because you accelerated. Same thing with payables. If you went and delayed the payables, now they're going to assume the business, they're going to have to pay those payables post-closing. But they weren't expecting that because that would normally have been paid before closing, but because you delayed it. So a working capital adjustment effectively takes a calculation of an average of your current assets minus your current liabilities and creates what's called like a target based on an average. And then what happens is it's like 60 days after closing, typically, we'll go forward after the books have been closed to show what the balance sheet actually looked like at closing. And we'll say, okay, what did the actual current assets minus current liabilities look like? So that if I accelerated receivables, I might have more current assets than, I might have less current assets because the AR is not there anymore and cash I get to keep. I might have less. So we would then calculate what it is, and then whatever that is off the average has to be a payment one way or the other. Either sellers have to pay it back to the buyer if it was one way, or potentially the buyers have to pay more to the sellers if they ended up getting a richer company than they should have based upon how the assets and liabilities happen to closing. And so that's something that is typically done. I think the terminology of net working capital makes it sound like cash that needs to be left in the business to keep it working post-closing. It's actually not really it. It's really adjustments off of sort of some historical norm of the business.
Let's go back to some of the legal documents you described earlier. Does someone have to agree to a non-compete to sell their business in your experience? And what does that typically look like?
Yeah. I would probably say in 99% of the instances, yeah, there's going to have to be some form of non-compete. And the reason is, they're not just buying, they're buying a business, an operating business. And that, as I'm sure you would all appreciate, much of your business is based on relationships, right? Relationships with customers, relationships with employees, relationships with vendors, all that. So if you were to be able to sell them this business and then turn around and open up another business right away, you would likely be able to take away a lot of those relationships that may have been with the other company, that may have been with the company you sold. And if so, then the buyer didn't get the benefit of their bargain. So it is extremely common that you would have to enter into some form of non-compete. And I'm not sure where everyone on the webinar is located, but many people I'm sure have heard like non-competes in California are generally not enforceable, and that is true. But that's typically only in connection with the employment context. A non-compete in connection with the sale of the business is usually respected by the courts. And the argument is you're being paid to not compete, hopefully millions of dollars. And so that is what's important though is, to the extent you're not looking to just retire and never work again, narrowly tailoring the non-compete is critical, I think, right? You need, I think it's reasonable for the buyer to ask for a non-compete to be limited to, if you did compete within that space, it would cause them damage. So that's what you need to think about. But if you're outside that space, you should be able to work if you want to. Like there shouldn't be. And the reason why it's so critical is, I would probably say most non-competes are, in connection with the sale of the business, are 3 to 5 years, with honestly 5 years being probably the majority of the time. So I think you got to prepare for that and understand that if you are planning on doing a competing business someday in the future, you're going to have to likely ride that out for that 5-year period.
Yeah, I think that's a good litmus test too on that right price, right time. If you don't want to sign a non-compete, maybe it's not the right time to sell.
Great point, Danny. Great point. Yeah.
So go in a different direction again, how can someone minimize the risk that they have to give back some of the purchase price they've received? Is there anything from a legal perspective they can do?
Yeah, well, certainly the disclosure schedules we talked about, right? That is without a doubt your best bet, because again, if you disclose these issues and the buyer suffers a damage because of it, they can't bring a claim against you if it's been disclosed. So that is step number one. Step number two is insurance. 10 years ago, nobody ever heard of rep and warranty insurance, but it's become extremely popular, to the point that I'd probably say it's in a majority of the deals we do now, where a buyer will go out there and obtain what's called rep and warranty insurance, which basically insures the buyer against claims that may happen post-closing. And the good news with that is the sellers aren't on the hook post-closing then potentially for claims. From a lawyer's perspective, we love it, because while most people spend a whole bunch of time negotiating reps and warranties, I'm trying to narrowly tailor them so I don't have to, I don't have to be on the hook. My client doesn't have to be on the hook for a bunch of potential risks post-closing. When we have rep and warranty insurance, I care less, because it's not, my client's not going to have to cover it if there's a claim. So we kind of go with the standard set of reps and warranties that the buyers provide, and we don't have to spend a lot of time, especially if the consideration in the transaction is my client's getting some portion of the equity in the buyer. A lot of times it'll be a cash and equity type transaction. In that case, if there was a claim, my client's actually benefiting from the insurance as well, right? Because some third party's actually covering it. Those are the two kind of legal ways. And by the way, there's usually a very hefty premium associated with those rep and warranty insurance policies, like, hundreds of thousands of dollars potentially. So you're giving up that consideration because somebody's got to pay for that. Buyer's going to say that's on you, seller, since you're the ones getting the benefit of it. But a lot of times that gets negotiated and split between buyer and seller. The other thing that you do to protect against having to give money back is, and this is something that the buyers will usually demand, I mentioned earlier, an escrow agreement. So a lot of times there will be some portion of the cash purchase price that, instead of going to the seller, will be put into escrow and held by a third party, that will wait for some period of time, usually 12, 18, maybe 24 months, to such that if the buyer suffers a damage for a breach of a rep or warranty, they can go back and make a claim against the escrow that's being held, as opposed to having to chase the seller and get money back that, hey, they may have already, bought some island in the Caribbean or something, where that's not necessarily, where the money's not there. And my job as seller's counsel is to negotiate as little of escrow as we can, obviously, right? Because that's money not in my client's hands at the beginning. But, hopefully if there are no claims, that money's just delayed and will be coming at some point in the future.
Got it. Well, I'll admit I've worked all the questions that I've been receiving in. I don't see any more in the queue. I'll try to summarize and please correct or add anything. Key thing is surrounding yourself with the right advisors at the right time. That's of critical importance. The diligence process and the disclosure schedules can make or break a sale transaction. And the sale process likely takes more effort than you're expecting. It's a grueling process. I don't know if you would agree with those or add anything.
Absolutely agree with those. But I will tell you, I have I have a lot of clients who, I've had clients that I've worked with for, 10 years and then go through a sales transaction. So, and many of them I actually call my friends because I've worked with them for so long. Uh, it is grueling. They were, frustrated through the process, but I'll tell you the happiness and the gratitude they have at the end of the process is why I do this job. To be honest with you, most people don't like lawyers. I get that. And litigators are, and most people don't like litigators because they're always fighting. I don't litigate. I love doing deal work because at the end of the day, buyers and sellers are generally marching to the same goal, right? Everybody wants to get a transaction done, and if it's done in a good way, everybody walks away happy. And my clients who do that, it's rewarding seeing them realize their dream because they have done something that I'm incapable of doing, and that is being able to build a business like that and build it into something so great. That is a huge task. You probably took a whole bunch of risks to get there, and you're finally realizing the benefits of that. And I'm excited to be able. I love being able to be part of that. It's truly fun, truly fun.
Well, also fun has been this call. I appreciate your time, Jonathan. I've enjoyed it. So thank you.
Thank you. I've enjoyed it as well.
All right. As a reminder for everyone watching, the next part in our series is October 19th, where we'll discuss from dream to deal, the steps in selling a business with Oksana, who is a business broker from IBG Fox and Finn. If you have any additional questions, feel free to reach out to either myself or Jonathan. We'll be happy to assist you. And thank you everyone for your time. And again, thank you, Jonathan.